Good afternoon, Your Honor.
Good afternoon. Mr. Mark Rankin?
Yes, Your Honor.
Okay. Good afternoon. Mackenzie LaPointe?
Yes, sir. Good
Good
afternoon.
afternoon, sir. And Roberto Martinez?
Here you are.
Okay, Mr. Martinez. Mr. Martinez, thank you for your hearing binder and attached documents. I found them very informative and helpful. And for the state, we have Mr. Donnelly.
Good afternoon, Your Honor.
You here by yourself?
I am, Your Honor.
Okay. All right, can we proceed? Anybody needs anything? I want to bring up one issue first, before, okay. The first issue I wanted to bring up is that as I was reading the documents provided to me by Mr. Martinez, I noticed that there was a depo of David DiPietro. I don't know Mr. David DiPietro. I don't think I would recognize him if he walked into the courtroom. But Nina DiPietro, it's my understanding this is his wife. She is a county court judge here, I believe in the civil division. And I need to know up front if that is going to cause anybody a problem. Is anybody requesting that I recuse myself, since I am also a county court judge in the same district, same circuit?
On behalf of Mr. Yuri, no problem.
Same, Your Honor. Bob Martinez on behalf of Lynn Barrett. We don't have an objection.
Okay.
Linda Roberson has no objection.
All right.
I have no objection on behalf of Rocky Rodriguez.
Okay, thank you, sir.
Mr. Fox has no objection.
Okay.
State of Florida has no objection, Your Honor. I think just to supplement the record, although you may have some information about David DiPietro before you, he has not been listed as a witness by either side, and there's been no statement that's been filed in discovery regarding Mr. DiPietro.
I went through the file and I looked at the discovery submissions. I did not find his name. I don't know, certainly he's not a defendant. I didn't know if he's going to be a witness or what his part is going to be in this. I take it, Mr. Donnelly, it's your understanding he won't be participating in this.
I'm sorry,
He will not be participating in this criminal action, is that correct?
he's not going to be a state witness.
Okay. Is he going to be a witness called by the defense at this time, that anybody knows?
Your Honor, Bob Martinez. It's hard to say, Your Honor. As you can see, the information that we submitted to the court is favorable to the defendants.
Right.
So it may be how, we don't know how this case is going to progress, or whether it will progress to trial. But certainly at this stage, with this hearing, I will be referring to his testimony.
Okay. All right, so the next issue, what I'd like to do is take up the defendant's motion for, the second motion for statement of particulars. Before I hear from the defense, I'm going to ask Mr. Donnelly, have you reviewed their motion, Mr. Donnelly?
I have, Your Honor.
What is your position regarding their motion?
We had filed a response the first time, and I think that was sufficient. That the indictment was actually very detailed in the sense, and I can go through this at a later time in this hearing as to what's contained in the indictment, and then we added, because under count one of de facto meetings, we added the dates to the locations and provided that information. Case law that I've seen, it seems sufficient by the state, but we'll deal with that as we go along today.
Okay, and gentlemen, correct me if I'm wrong on this, but I've reviewed everything, and it seems to me that what they're requesting is the specific statements or what was said at these meetings that would violate the Sunshine Law. Is that, am I basically correct on that?
That's correct, Your Honor.
Okay. Is that something you can or be willing to provide?
No, I will not, and the reason is because I think they misinterpret the Sunshine Law and what's required, and that information isn't even necessary for me to prove my case. And I'll explain that as we go along also. But I noticed in there, specifically, they're asking what witness says that this commissioner told this commissioner, told this person what this commissioner said. And that's not a requirement as we'll look at the case law. So no, we wouldn't be providing that information. That's not required.
All right. And knowing that, and I have looked at the indictment, I have looked at the defense motion for statement of particulars in the state's response to the first motion. I've reviewed the second motion. I've reviewed the documents contained in the hearing binder. And, Mr. Martinez, I'm gonna start with you since you provided all this material. Is there anything additional that you want the court to know or that you want to present to the court other than what's contained in here?
I would like the opportunity to do argument, Your Honor, presentation for the court.
Okay.
I don't think it'll take that long. There was a filing that we made this morning, I don't know if the court has it, affidavits from Jack Selden and Richard Westland.
Okay, I didn't see that. I did see yesterday, my, JA was out, she was ill, she's still ill. But I did see on the, MH Division email that you had filed the document.
Right.
But it was with a bunch of, and that's where Mr. DiPietro's.
Yes, that's correct.
Is that what's contained in there?
Yes, but I also had a filing today, Your Honor. I was
I
able
didn't
to
see that.
May I approach the
Yes.
next one? And I've
Have you
already,
given all of these things to Mr. Donnelly?
we have, Your Honor.
Okay.
He has. So this I'm handing the court a notebook, which is a notice of filing that was filed yesterday. These are the depot transcripts.
Okay, so this is what I reviewed yesterday. Got it? Okay.
And then, this morning, I was able to obtain these affidavits last night, actually one of them this morning. And I'm handing the court notice of filing the affidavits of Richard Westland and also Jack Selden, who are alleged to be two of the intermediaries along with Ms. Barrett.
Okay, so this is supplemental to this other notice of filing evidence, right?
That's correct.
Okay. So this is supplemental too, because it wasn't contained in here.
I just got those last night. That's
Okay,
correct.
very good, all right.
And
Those I haven't seen.
we filed them this morning. I have extra copies for you.
I see.
And Your Honor, I'm gonna be using some posters, but I have minis of them, so if I can hand them to the court, I also have it for the state. That's fine.
Mr. Martinez, let me, if I may, and I'm gonna let you present whatever you need. I just have to tell everybody I have to leave here at 3:30 to be at a doctor's appointment at 4. I tried to cancel it and I can't. So anyway, they're very particular, but anyways, so I just wanted to let everybody know that I'll give you as much time as you need. So as I looked at your materials, and it appeared to me, and correct me if I'm wrong, is your argument is more that your client should not have been indicted in this case, and it's more like a sworn motion to dismiss, not that it is because it wasn't sworn to. But that's what it seemed to me, as opposed to a motion for statement of particulars, a second motion.
Yes, Your Honor. And it may be that we will get there, Your Honor, and it may be that we'll also move to dismiss the indictment because it does infringe upon my client's First Amendment rights. She does have First Amendment rights. But I thought that before we get there, we would take this piecemeal. So I wanted an opportunity for the state to tell us, and tell the court, exactly what it is that they claim my client said to each one of these commissioners. Because words matter. The Sunshine Law violations is made up of words. It isn't just a meeting. It's what is said at the meeting. So it may be, Your Honor, that after this hearing today, depending upon the court's ruling either way, that we will file those types of motions.
Well, let me ask you, looking at the Florida Rule of Criminal Procedure 3.140, subsection
And
subsection B, it says the indictment or information in which the defendant is to be tried shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. Is it your contention that the indictment at this time and the response to the first motion for statement of particulars does not put the defendant on notice regarding what the essential facts are?
That's correct, Your
What
Honor.
are essential facts under the law?
Right. I can explain it, Your Honor, with my presentation, but may I do so, Your Honor?
And now what I'm saying is not the essential facts specifically to this case, but it hasn't been defined, essential facts been defined under
Right.
the law?
Well, Your Honor, I have to explain it. It's a little bit long-winded, but the essence of it is this: is that the Sunshine Law applies to board members, commissioners, or members of board or agencies. It does not apply to a staff member. I represent a general counsel, a staff member. There's the criminal statute under which they're proceeding is a criminal section of the Sunshine Law that applies only to board members. It's also specific to intent crime. My client, the only way a staff member can get implicated in connection with a Sunshine Law violation, even though it may be charged as a solicitation or a conspiracy, is if a staff member communicates to a member of the board what another member of the board told that person and passed it along about an action to be taken at an upcoming board meeting. That's the only way that a staff member can be implicated in a Sunshine Law violation. So as it pertains to my client, I represent a staff member, it has to be specific as to the words that are said. And if I could, that's the short answer, Your Honor. They can't just say a staff member met with a board member to brief him about a reportable event, because that's what they do all the time. It's got to be the staff member met with a board member and told that board member about a conversation told to her by another board member in connection with the matter to come before the board for official action. That would implicate the Sunshine Law under the case law of Occidental versus Mayo. But it's very limited. Under the Sarasota case, which we cited to the court, which is pretty much the case. It's a 2010 case decided by the Florida Supreme Court. All the current justices, except for Justice Perry, who was on the court back then, they basically said that it's common practice for staff members to meet with board members, and that is to be encouraged. That is not a violation of the Sunshine Law. There's no Sunshine Law requirement that meeting be noticed. The reason I submitted Mr. DiPietro's testimony is because at his deposition, and by the way, Mr. DiPietro, I know, because he's told us, was subpoenaed by Mr. Donnelly. He apparently testified in the grand jury, but I didn't ask him any questions about that. But he did meet with Mr. Donnelly at the state attorney's office. What Mr. DiPietro told us under oath, in our case, and by the way, he's very hostile to my client, very hostile. What he told us is that over a period of years, when he was the chair, and prior to that, the member of the board, without the chair's responsibility, he constantly met with the CEO, Mr. Nast, and also with Mr. Gorin, the then general counsel. Every time before a board meeting, they would meet at his office, at a restaurant, and they would go over those matters that would be coming up at the board meeting. And then Mr. DiPietro got debriefed, he asked questions, and he wanted to be prepared at the board meeting to act upon whatever matter it is that the board was going to act on. Those kinds of meetings that Mr. DiPietro had with Mr. Nast and with Mr. Gorin, or that these commissioners here, who are defendants represented by the lawyers here, had with my client, all of those meetings are not subject to the Sunshine Law. They don't have to be noticed. The Sarasota case sets forth extensively that that is legal practice. It's actually the best practice. I served, if I may, Your Honors, and aside, must have made myself as an expert, but I was the chair of the Miami-Dade College Board of Trustees for 6 years, and I served on the State Board of Education for 8 years, 2 of those years as vice chair. I constantly met with the president of Miami-Dade College, or later on the commissioner of education, before every board meeting, in depth, at my office, at his office, at a restaurant, on the phone, to talk about matters that come before the board. And those types of conversations were repeated by with each other board members. That's standard practice. The Sarasota case said that that's perfectly legal. What Mr. Donnelly has charged in the indictment is my client having those meetings. That's not a violation of the law. All Mr. Donnelly has said, may I use the poster for you?
Yes, but Mr. Martinez, let me ask you, I'm looking at, in your particular case regarding the defendant Lynn Barrett at count 3. The only thing that I am deciding today is whether or not I need to grant a motion for statement of particulars that you requested of the state. And is it necessary under Rule 3.140, indictments or information of the rules of criminal procedure? And I'm looking at the count 3, and it specifically states a reportable event allegedly committed by North Broward Hospital District Interim CEO and President Pauline Grant. where such de facto meetings were not noticed to the public and therefore not open to the public at all times. And at said meetings, matters pertaining to the North Hospital District business or official acts were discussed on which foreseeable action was taken by the Board of Commissioners. Isn't that sufficient as far as what is required under the rules?
Well, no, Your Honor, because they have to advise my client, they have to tell my client what it is that they allege she did wrong. That's a crime.
Well, that's what they're alleging.
But that's not a crime. Just this, what you read was this, Your Honor.
Well, then, wouldn't it be the proper vehicle then would be a motion to dismiss, not a motion for statement of particulars?
It might be, Your Honor. It might be the next phase. I think if this is all there is, if that's all there is, if they have nothing else to offer to you or to me today, if they don't have any evidence beyond just this.
Well, that, I don't know if on a motion for statement of particulars, I'm supposed to be taking in evidence. It's just whether or not the indictment and or information, but indictment in this particular complies with the rule. That's the only thing I'm supposed to consider, aren't I? On this particular motion?
Yes, Your Honor. But you are also, I believe that the rule allows, Your Honor, the rule under 1.340, and it allows a statement of particular if the indictment fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Now, we don't know what it is that they claim that my client said. Meeting with a board member about a reportable event, and I'll explain to the board what that is in a second. It's just meeting with a board member to talk about a medical program, or whether to hire an architect, or whether to elect somebody, appoint somebody for a certain position. It's just a subject matter. It's not, these aren't the words. These aren't the words that could be possibly illegal under the Sunshine Law. My client doesn't know what she's defending against. If it's just about a reportable event, well, that's not a crime. And yet they have charged her in count 3 and count 4 with violating the Sunshine Law. It's got to be more specific than just meeting with a board member to talk about a subject matter. It's what is it that was said? What is it that was allegedly passed on from one board member to another? That's the essence of a Sunshine Law violation as it pertains to any of these defendants, and more so as it pertains to my client, who is a staff member and who is not subject to the Sunshine Law. So what I was hoping the court would do today is to have the state provide to us a statement of particulars that lets my client know what is it that she allegedly said that violates the Sunshine Law, so that she can defend against it.
In other words, what you want the state to provide you with is the statements by your client regarding this reportable event, that, and what other commissioners said or felt or their opinion regarding it. Am I correct?
What I want the state to do, what I would like the court to do, Your Honor, is I would like the court to force the state to produce to me whatever evidence they have that they claim that my client said. Says, what words did my client say when she met with these board members that was a violation of the Sunshine Law? And for it to be a violation of the Sunshine Law, for it to be a violation of the Sunshine Law for her as a staff member, she would have had to have conveyed to a member of the commission something told to her by another member of the commission, as to the matter to come before the board.
Mr. Donnelly, you have a problem with that?
Yeah, because that's not the law.
What is the law?
The law, there's two cases that are right on point with this. One is the citizens of Sarasota versus the town of Sarasota, and that's the one that they mentioned. The other one is called Blackford versus School Board of Orange County.
Does anybody have those two cases?
I have copies for everyone.
Okay. I won't take up everybody's time to review them now, but basically you're saying that you can prove this case in other ways besides specifically what was reported regarding the reportable event.
There's a few other cases there also.
Okay, so what does citizens say? Or,
I'm sorry?
what does the case citizens say?
Citizen says this, Your Honor. In 2008, the city of Sarasota wanted to bring the Baltimore Orioles to the city of Sarasota to play spring training games there. So in November of 2008, they directed at a board meeting the administrator to begin negotiations with the Baltimore Orioles. He delegated that to his assistant. Over the next 7 months, which finally culminated in the 12th public meeting on July of 2009, they had these negotiations. They would go back and forth between the Orioles and the county, and after every meeting they would have it open to the public. The public could then come in, and the public could say what the issue was, and then they would go back and negotiate. So from November of 2008 until July of 2009, there were 12 public meetings regarding bringing the Baltimore Orioles to Sarasota for spring training. And the contract that was signed on in July of 2009, it was a public meeting. It went on for hours. It was posted ahead of time. Everybody knew what the contract would be. A few days before that, one of the staff went to each of the commissioners and they said, this is coming up. Do you have any questions to ask us about the contract? What questions do you have? There was never any discussion about other commissioners or anything. So they spoke with the staff members, each individual board member, and then they voted. And then there was an allegation made that this was a violation of the Sunshine Law. And the trial court, when it wrote its order, and I've included that for the court, the trial court went through its analysis of why this wasn't a Sunshine Law. And what they talk about, and what Blackford talks about, is a de facto meeting. But that's not mentioned anywhere in the city of Sarasota except in the trial court's order. So the Supreme Court in Sarasota said, look, there's no evidence that they met, that they relayed each other's what another board member was going to do. That's one factor of whether it's a de facto meeting. This was a scheduled meeting that they were going to have with them. This was the board members or the staff not telling the board members what their position was or how to vote on this item, this contract that was coming up. This meeting was just, do you have any questions of staff about the contract? And the Supreme Court said, that's not a Sunshine Law violation. And that is not inconsistent with Blackford versus School Board of Orange County. And in Blackford, what had happened was the Orange County School Board, they had a major redistricting problem. They had to move 6,000 students to different schools. So the superintendent was aware of the Sunshine.
Let me interrupt you for a moment, because I said, let me interrupt you for a
Sure.
moment, okay? I just want to make sure I'm understanding this. Mr. Martinez is saying that what he wants you to do is tell him how Lynn Barrett violated the Sunshine Laws, right? And you're saying,
What he wants me to say is that which person, in our case, board member, was that person's information conveyed to another board member.
Right.
I'm saying that's not the criteria for a de facto meeting. It can be a factor that goes into what a de facto meeting is.
okay, well, the to-wit clause in the indictment states it was communications regarding this reportable event regarding Ms. Grant regarding anti-kickback.
Maybe I should back up and explain what that is, Your
But
Honor.
what I need to know from you, and I'll let you do that, but what I need to know, you're saying there's another way that you're going to prove that Lynn Barrett violated this law?
I'm saying this is a de facto meeting, and that the information that they were presenting wasn't just fact finding, it was decision making. And under the de facto meeting, that is against the law, against the sunshine law. They want to focus on, what one commissioner said to another, or what was relayed about one commissioner's vote to another commissioner, that's the only way that a de facto meeting occurs, and that's not the case at all.
Okay, so can you tell them, in writing, what other way they violated this?
Sure, and that's in Blackford, the next case, Your Honor.
But what I'm saying is, why can't you provide that to them?
I have provided that to them in
The first answer?
that they met to to discuss a reportable event, which is a function of the Board of Commissioners to vote upon per the corporate integrity agreement. They have to determine whether it's a reportable event or not, and then they have to report it. They have to make a decision whether or not they're going to report it to the Office of Inspector General. And they, in fact, did that at the December 1st meeting. That was the second item that they voted on, that this was a reportable event, and we're giving it to the OIG. And that's why under count 1 of the information, counts 3 and 4, they deal with the reportable event. That is a function of the board. That is not a fact-finding function. That is a decision-making function. They hired someone to come in and do an investigation. He can fact-find, but then he draws a conclusion based upon his interviews with people that this is a probable violation of the anti-kickback law. Then they have another person, and therefore it's a reportable event. Then they have another person who doesn't do the investigation. He meets with everyone and talks to them and says, this is a reportable event. You must report it to the Office of Inspector General. And then they have the commission meeting. They don't bring in the fact finder. They bring in the other person who has now made a decision. And these meetings are with the various commissioners and the general counsel that's charged. And under Blackford versus School Board, that's what's called a de facto meeting. When they go to the hotel and they meet together to talk about this reportable event. When they go to the restaurant and they go there to meet and talk about it. And these are all factors that go into whether or not this is a de facto meeting or not.
When I look at this, what I understood, and please correct me if I'm wrong on this, because this is the way I understood it. I understood there was some issue regarding Ms. Grant, right?
That is count 2, Your Honor.
Well, I'm looking at Lynn Barrett's count 3. Okay, count 3 and 4. Just let me finish, because if I can say it, then it's clear in my mind. Okay. So my whole understanding of this, and I'm just talking about Lynn Barrett's allegations right now, is that there was some kind of an issue regarding the CEO, President Pauline Grant, regarding some kind of kickbacks, right? And so then the commissioners met with Lynn Barrett and discussed this incident, which is called a reportable event because it has to be reported, right? Under the agreement, I think it's a CIA agreement. Okay. So that makes it a reportable event. And they're discussing this, the allegations are they're discussing this, and they're discussing in those meetings what the other commissioners said, or what the other commissioners. No,
they're not.
Okay, so
No,
clear
they're
me
not.
up on that.
I'm sorry.
Clear me up on that. What am I missing?
Okay, they hire Mr. Westling, and he comes down with 2 other individuals. They go and they interview various people at the hospital district. Instead of writing a report and submitting it to the board, saying, these are the people we interviewed, this is what they say, he then makes a determination that this is a probable violation of the anti-kickback, the START law. And then he reports that to Ms. Barrett. She then brings in another attorney, and she has Mr. Westling call certain commissioners and inform them over the telephone of his investigation and his conclusions. And he also concludes that it's a reportable event. So he not only concludes that it's a probable violation, but that it is also a reportable event.
Up to that point, is that a violation of the sunshine law?
If that were the only thing that happened, no.
Okay,
I
so-
wouldn't think that there would be proof to obtain a conviction on that, and I don't think that would have happened, but it doesn't stop there.
What happens next?
Well, he first contacts two of the people on November 14th. He then contacts one of the individuals on November 15th, doesn't reach out to the other three people at that time. Then the day before the hearing, the meeting, he then meets with Ms. Barrett, Mr. Selden, who's the other attorney, and the chairman. And they meet at a restaurant over here on Federal Highway, and they go through and they talk about the reportable event there, the investigation. And after that meeting, then the chairman calls the clerk, and they change the agenda for the next day. So
But in that meeting, you're saying is a de facto meeting?
that is one of the de facto meetings. Now we
It's
go
in violation of the sunshine law.
correct. Now we go back to November 15th. After Mr. Wessling had contacted, he contacted Ms. Capeso, Linda Robeson on the 15th. After that contact, then on the 15th that morning, Ms. Barrett, Jack Selden, and Mila Rice and another attorney, they go over to the Westin Hotel and they call certain commissioners to come over there, and then they spend time and they brief them on the reportable event. So you have Miss Beverly Capasso, who shows up there, and she's in her golf attire. She meets with them in the conference hotel room. Then Mr. Uri, they speak with him on the phone. He can't get away, so he speaks with them on the telephone, on speakerphone, as to the reportable event. And then you have Linda Robeson, who shows up at the hotel afterwards, and she meets with them, and they then brief her. And then, so that is the other de facto meeting, each one of those meetings, and then you have the one with
In my
Mr.
understanding,
Rodriguez.
Mr. Donnelly, so they're not supposed to have those meetings at all?
No, it's held in secret, off campus. Now they may disagree about that because they say we can meet with staff, and if that's their position, file the motion to dismiss, and I'll provide the case law which says otherwise to the court. But when you look at Blackford versus School Board of Orange County, when the superintendent met with each of the people during what they called de facto meetings like that, he did not tell this commissioner what that commissioner said or anything like that. And the court said, you don't have to. That's why that can be a factor to show a de facto meeting, but it's not necessary on its own. So we get into with staff, and throughout their motion, they keep saying staff can meet with them at any time. Well, there's a caveat. Staff can't meet and talk about a de facto meeting, and then they are subject to the Sunshine Law, and the case law is replete with that. So, yes, there are certain factors that make up de facto meetings, but just relaying the information of one commissioner to another doesn't.
So, okay, so, and I think you did, let me just.
I should say one other thing, Judge,
Yes, sir.
because you had asked about Ms. Grant. It's the fact that the board has to vote on the reportable event. That's what's on the board on the agenda that day. And what happens is they bring Mr. Selden in, and he addresses the board as if nobody had ever spoke with him before. And you can look, if you look at what was said on the December 1st meeting, you said, if that was said outside of the room, there's some of your evidence of a de facto meeting. Now, later on during that meeting, well, the first thing that the board does is they hire an interim CEO, Kevin Fusco. Then they vote on the de facto, on the reportable event. And then they fire Ms. Grant, they realize, hey, we didn't fire her. We hired Mr. Fusco, but now we got two CEOs, interim CEOs. So they vote to fire her and to hire him. That action there, that vote, is the subject of count 2 of the indictment. That has nothing to do, though, with Miss Barrett. Miss Barrett is only on counts 3 and 4 as they relate to the reportable event. And so when they fire her, the allegation in count 2 is there's no notice that this is going to happen. The board only has control over 3 of 9,000 employees there, who they fire and who they hire. And there was no notice, no opportunity for the public to be heard. And that's what's in the 286.011 and 286.014 in the statutes.
And it's your position that staff or an attorney, such as Lynn Barrett, cannot meet with each of the commissioners individually and have a meeting with them?
No.
Because that's a de facto meeting.
No, what I'm saying is staff can meet. I think when you read Sarasota, staff can meet with individuals unless it becomes a de facto meeting. And there's a lot of criteria, factors that go into a de facto meeting. And that's what they cannot do. And she's charged with soliciting and setting up the meetings and all of these other things.
Would you be able to indicate what it was that, in these meetings, that made it a de facto meeting?
They have all that information.
From where?
They have it in the discovery. They have it, they provided a couple of affidavits today from Mr. Selden and Mr. Wesley. But their whole premise is that this isn't a crime because she didn't relay, or they didn't relay what this board member was going to say to this.
I know, but that is a subject of a motion to dismiss. It's more motion to
Exactly.
dismiss. I'm just here today on the
Right.
statement of particulars, and
If you look at the only case that they cited in their motion for a statement of particulars, it's the Easterly case. It's the only motion other than Sarasota. But Sarasota doesn't have anything to do with the motion for a statement of particulars. So the only case that's cited is Easterly versus State of Florida. And Easterly has nothing to do with anything that we're doing here. It's a sex battery case where there was a question as to when the incident, the conception of the child occurred. And so they looked to this other sexual battery case where the indictment said there was a 27-month period from beginning to end where it could have occurred, and the court said that's okay. So I don't know what that has to do with this case here.
And your feeling is that your state's response to the defendant's motion for statement of particulars is the first one, plus the indictment, plus the discovery. And the discovery you're talking about is discovery in this case, or the discovery also in the civil case, which was?
I don't have any of the discovery in the civil case.
So it's all
The discovery I have provided. Now, they have taken depositions of my witnesses in the civil case. I haven't been noticed. I haven't been party to it. I haven't received any of those. This packet that we got yesterday from Mr. Martinez, which had summations of some of the witnesses' testimony, I haven't received any of those statements of those people. They haven't filed any response, any reciprocal discovery, haven't listed some of those people that are not listed as state witnesses in discovery. But that doesn't matter. It doesn't have anything to do with what we're here with today. But their motion, when I read through their motion and everything that they allege in all the paragraphs, number one, they're grabbing the head notes and partial head notes without reading what the facts of the cases are and what the cases actually say. So when they say, I have to prove this, we want who told Ms. Barrett what this commissioner said that she relayed to this commissioner. I don't have to prove that. That's not the law. And if they think it is a law, then file the motion to dismiss and we'll respond.
That would help me a great deal. What is it, you can go forward again.
I have a hard time hearing sometimes.
That's okay. What is it that you feel that you have to prove on Ms. Lynn Barrett on items 3 and 4? I know one is conspiracy and okay. But what is it that you have to prove as far as these meetings?
She set these meetings up, that they had the meeting was set for December 1st. It was to discuss foreseeable events that were coming before the meeting, and that if you look at the statute, the Sunshine Law, 2 or more members, the meetings have to be public, there have to be minutes taken, and there has to be notice. And when you do a de facto meeting, it's when you're using staff as a conduit for whatever reason. And that's what the
I think I understand.
other case says.
Okay. And Mr. Martinez, you don't agree with that?
No, not at all, Your Honor. May I address the court? I'm glad we're in a court of law, because we have to be precise. When Mr. Donnelly, my friend Mr. Donnelly, tries to use as proof the theory is the term de facto meeting, as if de facto meeting carries with it some sort of legal connotation that is magical. A de facto meeting is a meeting, in fact, it is not a name. That's what de facto means. Now, in the context of a Sunshine Law, in order to have that kind of a meeting, what he has to show, what the state has to prove, is that a staff member met with a board member and they talked about, they communicated a conversation from another board member to that board member about a matter to come before the board.
He says that's only one way. Mr. Donnelly is saying that that's only one way. That is not the only way.
In Blackford, if you read Blackford, that's what that says.
Okay.
So Blackford, let's talk about Blackford. What Mr. Donnelly hasn't told you about Blackford is that in Blackford, the Court of Appeal found that there was no criminal culpability. No criminal culpability. And the Blackford case is, frankly, Your Honors, sui generis to the extreme. In the Blackford case, there were meetings between a superintendent and school board members done over a period of 2 days. So he met superintendents with board members over 2 days. He repeated that 5 other times over a period of 3 months. So the superintendent met with 3 board members one day, 3 board members another day, repeated that same scheme 5 other times over 3 months. And during those meetings, what evolved is the proposal by the superintendent with regards to closing down a particular school. And every time he met with the board over those 3 months, he refined what he was ultimately going to present to the board at the public meeting, which he did. There was a public meeting. And what the Court of Appeals held there was that those were rapid fire, quote unquote, rapid fire meetings. That's the term of art they use. So that's unique. And basically saying because the proposal that was ultimately presented at the board was developed and refined over time during those 3 months in those 6 sets of meetings. In fact, those meetings were de facto meetings. We don't have that here at all. We don't have that here at all. The more pertinent case with regards to this issue is the case of Occidental versus Mayo. Now, I haven't given it to the court, but it is cited in the Sarasota case. And what
Occidental?
in the Occidental versus Mayo case. In the Sarasota case, Your Honor, you can find that it is the Occidental versus Mayo case. It's on page 764, and it's also cited in the Blackford case. And in the Occidental Mayo case, this is a Supreme Court case, 1977. This is one of the first times in which the Supreme Court of Florida dealt with this issue of a conduit, the issue of a conduit. And in that case, the Supreme Court, Justice England, held that there wasn't any evidence that, in fact, a conduit was used. There was the communication sent from one board member to another board member by a staff member. And in fact, I think it's important to read the following language in the court from the Occidental versus Mayo case. It's on page 341 and 342 of the court's opinion. Occidental argued that because the agenda conference lasted only 90 minutes, that which was public, only 90 minutes, and resulted in the adoption of pre-prepared staff proposals, the commissioners either met in private to reach a consensus or delegated their decision-making responsibility to staff. And the Supreme Court goes on to say, admittedly, the adoption of the multi-page decision document at the end of the complex rate cases was before the Public Service Commission. With minimal pertinent discussion publicly, creates an appearance of prejudgment. Creates the appearance of prejudgment. There is, of course, no evidence in this record that the commissioners met in secret or used staff members as intermediaries in order to circumvent the public meeting requirements. So the Occidental case, which is a case cited by Blackford later on by Sarasota, that's the case that basically says, you know, there is an exception where a staff member could violate the Sunshine Law, although a staff member is not subject to the requirements of it, where there is evidence. This is the same thing that the Sarasota case, Sarasota court held. Sunshine Law is not violated, Your Honor, where there is no evidence that staff communicated what any commissioner said to any other commissioner. That's the crux of the quote-unquote de facto.
Mr. Martinez, I'm sorry to interrupt you, but I still am getting the feeling that you're arguing a motion to dismiss. All I need to know here is on the statement of particulars, whether or not it is complied with this rule, and I'm looking at the rule. What do you find,
Well, I guess,
as far as the indictment itself and the response to the first statement of particulars, how does this not comply with the rule?
because the rule requires that my client be put on notice as to what it is that she did wrong that violates the law. And just briefing a board member is part of her requirement, and it's not a violation of the law. But talking to a board member about a reportable event is not a violation of the law. In their statement of particulars in response to my first motion, all they did, Your Honor, is they basically provided conclusory language. All they did was to say the following. All Mr. Donnelly did is he said, okay, we're going to give you further information with regards to what you request. And this is the information. Information related to a reportable event was disclosed. That's it. That's all he did with regards to his statement of particulars. And that's not a crime. So I think I'm hearing him today say, Your Honor, there is a court report that he doesn't have any information about what my client said to a board member that came from another board member. Apparently he doesn't have that information. So all he's saying is that his theory of liability is that it doesn't matter. It's just a mere fact that my client was meeting with a board member.
Well, I'm looking at the response.
Yes, sir.
Okay, and Lynn Barrett did personally or through conduits or intermediaries, and they named the people, to privately discuss at the Westin Hotel, Mario Catalina Restaurant, or through telephonic communication, a reportable event allegedly committed by North Broward Hospital District Interim CEO Paula E. Grant, where such de facto meetings were not noticed to the public and therefore not open to the public at all times. Doesn't that put Ms. Barrett on notice as to what the allegation is?
But not as to what she said. The term de facto meeting, Mr. Donnelly believes that by saying de facto meeting, all of a sudden it converts an innocent meeting, perfectly legitimate meeting, to something that is illegal. Or make something de facto under the law, under Occidental versus Mayo, or the Blackbird case, or the Sarasota case, is whether there's the essence is the word. What words were communicated by the staff member to a board member that came to another board member? If that's communicated, then that is a de facto meeting. But just meeting with a board member.
Well, it says, and at said meetings, matters pertaining to the North Broward Hospital District business or official acts were discussed on which foreseeable action was to be taken by the Board of Commissioners.
That's standard operating procedure. Whenever I met as the chairman of Miami-Dade College, or as the vice chair of the State Board of Education, whenever I met with the president or the commissioner of education, or whenever Mr. DiPietro, the prior chair, met with Mr. Nass, former CEO, those meetings dealt in preparation of a board meeting. All of those meetings always deal with a matter to come before the board. It's to be prepared.
Well, I'm not saying that one way or another that this is a violation of a crime or the violation of the statute? All I'm saying is, doesn't this comply with the rule as far as what must be contained in the indictment or information?
And Your Honor, and to answer your question directly, I believe, to answer your question directly, that the state needs to let my client know exactly what it is that she said. Because just briefing a board member is not a crime. What is it that they allege she said to a board member that comes from another board member? They accuse her of being a conduit.
Let me ask you. This would be proven through witnesses that were allegedly there, am I correct?
Correct.
And you have listed those on the defense witness list?
I'm sorry, on the
Have
defense,
you listed the witnesses on the defense witness list to prove what was said at the meetings?
I've listed my witnesses, which,
So, I know that you haven't taken the depots in this case because you were taking the depots in the other case, okay? Doesn't that tell you
We did
what
take,
was said or not said?
yes, Your Honor, we took depositions of the witnesses in his list, his witnesses, Mr. Donnelly's witnesses, because many of those witnesses are also on the witness list in the civil case. And not a single witness has said that, has any information.
But that's for a motion to dismiss. I understand that, okay? Or a sworn motion or judgment of acquittal. Just talking about the statement of particulars, I mean, in a capital murder case where there's a death penalty, at least when I was doing them, I mean, you did not have to put in the indictment that the man snuck through the window at 3 p.m. in the afternoon. He pulled a knife, he stabbed the person in the living room 3 times. You don't have to go into all of those facts. All you have to go into is to put the defendant on notice what he is alleged to have done. But you don't have to go to the facts. The facts come from the discovery.
Of course, Your Honor, but in that case, it's obvious that the crime is homicide, killing a human being. Here, the crime isn't just meaning, it's words. The crime, alleged crime, is what words were said. It's not just meaning, it's what words were said.
And your feeling is that those need to be stated either in the indictment or response to statement of particulars.
Right, and before filing a motion to dismiss, and we are going to go there one way or the other, regardless of the court's ruling, I wanted to make sure that we flushed out all the opportunities to get whatever information the state could provide to us.
Let me ask you this also. Really, I'm talking to everybody. Your second motion here was a Brady motion.
Specific Brady request.
Okay, for the state to provide you with any Brady material they have. And I think my understanding is the state is under that obligation all the time anyways, even without a court order. And I would assume, and I'll ask Mr. Donnelly, have you provided them with all the information, including Brady information?
I provided them everything that I have. I think that when you look behind these motions though, for the Brady and for the grand jury testimony of Sam Gorin, there was a first motion that was filed for grand jury testimony, which is an allegation that I engaged in prosecutorial misconduct. These motions are the same. They want grand jury testimony, which they're not entitled to have. And as I told the court earlier, they've taken depositions without me being noticed. That's fine. They have the depositions. They haven't filed them or provided them. I don't know what's in those depositions. If they want to provide those to me and I read through them and I see something that might be Brady, I would certainly turn it over. I've turned over everything that they have involving my file.
Is there anything, and Mr. Martinez, I apologize to you because I know I keep interrupting you.
You're the judge, Your Honor.
Well, I just want to make sure I understand everything. What is it, besides any kind of grand jury testimony, what is it that you feel the state has that would come under Brady that you feel that he has not given you?
Well, I don't know, Your Honor, but let me give you an example of information that has come to our attention that he didn't provide to us. Maureen Canada was a board member of the North Broward Hospital District, and we know that she spoke to the prosecutor. We have her sworn statement. We know that she went into the grand jury, I believe. We didn't ask her about that. When I took her deposition in the civil case, she's a witness in that case, she was totally confused about notice and agenda. And notice,
I read that.
okay, and at the deposition I said, are you gonna let Mr. Donnelly know that you were confused about this, because your sworn statement confuses notice and agenda? And the next day they sent a letter to Mr. Donnelly, their lawyer, recanting. I never got that letter from Mr. Donnelly. He's had that letter for months. I got that letter from the lawyer for Ms. Canada. I believe Mr. Donnelly, under Brady, has an obligation to have turned that evidence over to all of us on the defense side, because that recants the testimony of a critical witness against our clients.
Mr. Donnelly, do you have that letter?
Well, we can address, I mean, there's specific cases in the first motion that I responded to that deal specifically with this. They took this, they had her statement. They took her statement. She changed her testimony apparently. I haven't read her testimony. I don't have her testimony. I'm under no obligation at that time to go get grand jury testimony to turn over to them. If they turn a statement over to me and I read a statement and there's something significant, but just because a witness changes their testimony about something where she's a lay witness and they're asking her opinions about notice and agenda, apparently, that's not Brady on my part.
But let me just ask you this, did you receive a letter from the attorney for Mrs. Kennedy? Indicating that she was wrong or that she wanted to
I
change?
received a letter. I glanced through it. I put it in the file, Judge, because they had already taken a statement from her.
I understand what you're thinking. I think though that you should have provided, and I would ask that you provide all
I
the.
have no problem doing that.
Okay. And as far as the second motion, which, okay, certainly, I don't even know if it's necessary with Mr. Donnelly to enter an order, but I will enter an order asking the state to provide the defense attorneys with any documentation or evidence they feel is exculpatory or it comes under Brady.
Well, I glanced through this document that was presented to me yesterday, and they go through and they ask these
Which
witnesses. The only one I got from the defense, which was a summation, or not a summation, it had excerpts of witnesses' testimony.
That's right here. It's notice of filing evidence support a second
Right.
motion statement of particulars.
I got a copy of that yesterday afternoon with just excerpts of people's testimony where they're asking them, did you see my client commit a crime? No, I didn't.
Well, they have that.
Right, but
provided
that was filed with this motion in mind.
Well, I wouldn't think that you would need to supply them or send them back things that they sent you. I mean, they already have it. But what I'm saying is things that you feel that they don't have and that haven't provided that come across. I know that you would always send it to the defense
I
attorney.
will turn over that letter, Judge.
Okay,
I know of nothing else though.
Well, if I may, Your Honor?
Yes.
For example, David DiPietro, here's a good example. David DiPietro, in his deposition in the civil case, at length, told me about the manner, told all of us under oath, as to how he used to meet with Mr. Nass, the former CEO, and Mr. Gorin, the former general counsel. Anywhere, his office, restaurants, they tried to cast aspersions, Mr. Donnelly did it here again today, to some of these meetings with the commissioners were at a hotel or at a restaurant. Mr. DiPietro said that he regularly met at restaurants with the former general counsel. And he also said in his deposition that it was a common practice for the CEO and the general counsel not only to meet with him, but with all the other board members and to go over the same matters, but separately.
I
Now-
think he said mostly it was out of his office. Right?
Mostly out of his office, that's right. Now, Mr. DiPietro testified in the grand jury. I assume that he testified consistently with the way he testified in his deposition. If he did, then that's information that is exculpatory, because that's consistent with our defense. There's nothing wrong with those meetings, and there's nothing wrong with those pre-meetings before the board meetings. To have those individual meetings with board members, even identical ones with each board member. Presumably, Mr. Donnelly has all that from Mr. DiPietro from the grand jury. That's Brady. Now, he should have produced that to us. My motion for Brady isn't just a general Brady request, it's very specific. And I've set forth in our specific Brady request all of Ms. Barrett's defenses. She has several, starting with the fact that she didn't violate the law, through the fact that she relied on advice of counsel, etc. So I don't think that Mr. Donnelly can satisfy his obligation to comply with a specific Brady request by writing me a letter and saying, hey, there's no exculpatory information. I think he's got to go into the record that he has and see whether or not he has any evidence, or through the exercise of due diligence, discover evidence that is consistent with our defense, as I've set forth in our specific Brady request. The state has those powers, and the state has those responsibilities after a specific Brady request has been made, as I have done here.
Mr. Donnelly, what is your position regarding the statements of witnesses, either sworn testimony to you or your investigators, or to the grand jury, that you feel are Brady? What is your position regarding submitting them to the?
I've turned over every statement that was provided to either me or to an investigator during the investigation. They have all of those.
What about grand jury?
Grand jury testimony, I've provided them the testimony of the 3 defendants who testified in front of the grand jury, the transcripts and the tapes, because the transcripts, the court reporter had some trouble, to put it mildly. And those have all been provided to them. But as far as specific testimony of other witnesses in the grand jury, no, there's no Brady that I'm aware of, and I don't think that that's Brady, what he's talking about with respect to Mr. DiPietro.
Why do you think? All I know is the excerpts
Yes, sir.
that you provided to me. What is it about that you?
Sure.
You weren't there at the grand jury, of course.
Of course.
Okay. But what is it that you think Mr. DiPietro testified to in there that is?
I assume that Mr. DiPietro and the other board members who were not indicted testified consistently with the way they testified in the deposition. Mr. DiPietro, for example, what he told me in his deposition was that he had these meetings, these de facto meetings. He also had these same types of de facto meetings that Mr. Donnelly says are illegal. Mr. DiPietro in his deposition, he had them all the time. If he also provided that testimony in the grand jury, well, that's exculpatory, because it basically, it supports our position, that is, that there's nothing wrong with those meetings.
But you have his testimony from the deposition, right?
Because I got it independently, but if there's additional evidence in the grand jury from Mr. DiPietro or Ms. Canada.
But grand jury testimony is a completely different animal, isn't it, than regular depositions or?
It is, but it's my understanding that Brady would trump the state's. Respectfully, I believe, I could be wrong, but I believe that the Brady, which is a constitutional decision, would trump the state statute as to the grand jury secrecy, if in fact there is exculpatory information within the grand jury testimony. I don't know what's in there. I think Mr. Donnelly has an obligation, having received a specific Brady request, to see whether the testimony of the witnesses that testified in there have information that is consistent with our defense as I have laid it out.
Well, Mr. Donnelly, you were there, weren't you?
I was, and I'll give the court, this is the response I filed to the first motion that they had filed for grand jury testimony. And near the last probably 10 pages, I go through all the case law with respect to grand jury testimony and what they have to establish in order to get grand jury testimony, even for the court to review the grand jury testimony. And David DiPietro isn't listed by the state as a witness in this case. To my knowledge, he has nothing to do with the December 1st meeting. He was long gone as a commissioner by then. If they're saying because this person over here committed a crime also.
Have you listed Mr. DiPietro as a witness in this case?
We just took his deposition recently. We may listen, Your Honor. We told Mr. Donnelly that the discovery was not concluded yet, and we didn't know what a witness or exhibit this would be. We just, as you know, we just recently got a judge in the case.
Right.
So, but we will do that in due course. We have no, the kind of the ironic thing here is that the specter over this whole case by the state is that our client hid something, has something to hide. We have nothing to hide. We will turn over all the depositions. We're an open book. And yet, we don't know what Mr. Donnelly did in the grand jury. I was actually in the grand jury with my client, and I'm not going to disclose it, I've been in the grand jury before many times as a federal prosecutor. What I saw in there, without describing it, was unusual. Unusual. And I have been in hundreds of grand juries. I wasn't very happy with it.
Okay, well, we're not gonna get into it.
We're not gonna get into that. That's a subject matter for another motion that is not, set before the court today. But, if you want, Your Honor, we can give the court the deposition transcripts and let the court or somebody else compare it with the testimony of those same witnesses in the grand jury.
Well, I don't think it's my duty or function to compare all of these and then decide which is gonna, I think it's Mr. Donnelly's, obligation that if he has any knowledge regarding any evidence that it comes under Brady, that we all are under the obligation to provide it to the defense. And so I'm just going to order that he does that. I'm not gonna specify exactly what it is, because I don't know. But, anyways, anything else regarding the statement of particulars?
Thank you, Your Honor.
Yes, sir.
Bruce Lair for Commissioner Urey. Your Honor, looking at Rule 3.140N, and I quote it, that the charging document fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. The statement of particulars shall specify as definitely as possible the place, date, and all other material facts of the crime that are specifically requested and known to the prosecuting attorney. I sat down with my client when I got the indictment, and he said, well, what are they saying I did wrong? And I said, quite honestly to him, I don't know. So I moved for a statement of particulars. Got the statement of particulars, read it 3 times, scratched my head, and said, I still don't know what you did wrong. Your Honor, I cannot file a defense witness list. I cannot file anything until I understand what we're defending against. It would be, all I'm asking for is a level playing field. No gotchas at all. Fair play. Whether the state has found an innovative way to make what happened into a crime, or if the defense position is correct that what happened is not a crime, I have to know what happened. And right now, I don't.
Mr. Lair, let me ask you this.
Yes, sir.
What they talked about, would that suffice, or do you need specific statements of your client? Is that what you're asking the state to do, is specific statements by your client, or what was said by each person, or what the subject matter of it was?
Right now, my client knows that he had a telephone conversation in trying to fulfill his obligations as a commissioner to learn what was a reportable event. He didn't have it with any other commissioners. He had it with staff. He had it with legal experts. So I need to know what either the subject or the exact language, whatever would tell me what I'm defending against. Because to be a commissioner doing your job, you got to find out what the law is. To become a commissioner, and my client is not an attorney, you have to find out from staff, from legal experts, what is the law on the vote you're going to take. So my client has no way to know whether these people met with the 4 other commissioners or not. There's no allegation that he was told, okay, we met with the other 4, now we're going to meet with you. So to say that this is a crime without giving me the specifics, I'm not arguing a motion to dismiss here. I'm arguing that I do not have the opportunity to know what my client did wrong to defend against. And that's why I'm in need of a second statement of particulars, because the first one didn't get me any closer. On the Blackford case, they talk about specifically planned successive meetings to discuss exclusively the major redistricting problem. I don't know what problem it was. That is on the bottom of page 2, very last line of page 2. My client, he's a commissioner, he's not a lawyer, and he's told, okay, we want to inform you about a reportable event. What? How you should vote on the reportable event? how other people feel about the reportable event. What was said, just having a meeting with lawyers, not knowing if anyone else has met before, not knowing if anyone has discussed anything before, just having a meeting with your staff and your lawyers cannot be a crime. So to this day, all these months later, Mr. Uri says to me, what'd I do wrong? And based upon the first statement in particulars, I have no idea. I'm not asking for the law as to whether the state is correct on what's a violation of law, or the defense is right on the violation of law. I just want to know what happened that violated anything. And the first, not to be rude, the first response was gobbledygook. It did not tell me anything. I need to know as much as I can find out, which will enable me to tell my client, this is what you did, and they're saying you shouldn't have. I have no idea at this point what that is. And this case has been pending a long time. I have no idea.
Let me ask everybody, my understanding is the only response that the state did a statement of particulars was to Lynn Barrett's case 3 and 4, right? Counts 3 and 4.
No, sir. It was my statement of particulars originally.
I have the state's response to statement of particulars. Maybe I didn't get all of them. It's Lynn Barrett, talking 3 and 4. Count 3. Then count 4. I don't have the.
Ms. Mackey responded on the statement of particulars, and I do recall Mr. Uri's response, because Mr. Uri,
Was this
were-
filed?
I'm sorry.
Was this response filed?
Sure it was. Sure. They have.
I have it. I just didn't bring it with me. I'm sorry.
But because the response identified that on the 15th of November, on the 14th of November, he had a conversation with Mr. Westling, and then on the 15th of November, there was a conversation with Mr. Selden, and that was specifically as to Mr. Uri.
Well, having a conversation with an expert cannot, in its own, be a violation of the Sunshine Law. So I need to know, if I can't know the exact language I think is appropriate for a level playing field, at least tell me what was discussed. Where is there a violation of law? It's like saying committed a battery to it. What? Threw something? Touched something? What? What has he done wrong? And we're so far into the case, I don't have an answer.
Okay, well, I'm looking, and I did find, and I apologize to you, Mr. Lair, there's defendant Uri's second motion for statement of particulars. And I see the order granting the statement of particulars. But I don't see the state's response in the Uri case.
For the first motion for statement of particulars?
Right.
Sure. I don't even think, I didn't think there was an order. I think we
There wasn't an order.
voluntarily
They did voluntarily.
answered that.
Well,
Yes.
I'm looking at a stipulated order under Christopher Uri, March 1st, 2018, defense motion for statement of particulars hereby granted.
That was upon agreement in court.
Right, but what I'm saying is I don't have the statement of the response to the motion for statement of particulars from the state, from Mr. Uri. You file one? You said you don't have one with you, right?
Something was filed.
There was one.
I don't have one with me, Ms. Mackey handled that.
Here's the defense motion for transferring case, file defense motion for statement of particulars, motion to compel, order granted for statement of particulars.
Excuse me, Your Honor, if it helps, the state filed one as to Linda Robeson, and it was filed on March the 27th, in case it helps you to look at the docket. They were probably all filed around the same time, I'm assuming.
And what date was it?
March 27th, 2018.
Okay. Thank you very much. It helped me a great deal.
You're welcome.
State's response.
I'm helpful once per case, so that's it.
Just give me 1 second.
I'm sorry.
Okay, so what it says is, to wit, a discussion relating to a reportable event allegedly committed by North Broward Hospital District interim CEO and President Pauline Grant. It's stating it right there what the subject of the discussion was.
Except it's saying that the commissioner had a meeting with legal counsel and a legal expert discussing an issue, and that is the violation of the Sunshine Law.
Well, again, that's either up to the fact finder or up to me on a motion to dismiss. But I'm just talking about, again, a statement of particulars.
I would ask that I be provided with what was said, so that I can tell my client, when you said this, you committed a crime.
The date and time, fact on meetings. Okay, the telephonic meeting that took place with Richard Westman.
In other words, Your Honor, if my client said to Mr. Westling, can you define for me a reportable event? I can't imagine that's the state's case. I need to know what was said that amounted to a violation of the Sunshine Law.
Okay.
Your Honor, can I just
Yes.
make one point?
Yes, Mr. Lyon.
Obviously, the court has recognized that at some point there will be a sworn motion to dismiss. The court has now have a preview, because all the cases that are going to be relied upon by both the state and the defense are already out on the table. It would seem to me that what the prosecutor is indicating is not what we perceive to be a violation of Sunshine Law, i.e. they meet and Commissioner A is told what Commissioner B thinks about what's going to come up. The state's position seems to be that you're not supposed to meet anywhere other than at a board meeting, and that having the meeting, the one meeting with each of those commissioners, whether it is by telephone or whether it is in person, is a de facto violation of the Sunshine Law. That is their theory of, appears to be their theory of prosecution. Well, to the extent that they need to know what it is that they did, at least the state could indicate that the violations here are, one, each one of those commissioners having a meeting, and two, that they were not at the office, they were at a bar, or they were at a restaurant, they were on the telephone, they were somewhere, and that shouldn't have happened, and that's the no-no. Because it seems to me, at least we learned today, what their theory of prosecution is. I mean, it's pretty clear. Tim is being transparent to the extent that he knows, that's what he said today to this court. That's what it is. So to that extent, at least they can advise us. So we say, okay, that's what it is. Now we know that their theory is not that each of the commissioners found out what each of the other commissioners said or did, but that they shouldn't have met, or they shouldn't have spoken, or they shouldn't have done anything. And obviously that'll obviously be the subject of a sworn motion to dismiss, where you will then be, from a factual standpoint, be in a situation to make a value judgment, assuming that there's a demur and the court has the law and the court makes a decision about it.
Judge, I would be satisfied if I may. I'll make an ordinance motion in limine right now. If what was said is not consequential to the charges, then let's exclude any of the subject of conversation, because either they're relevant in proving this crime or they're irrelevant. If they're relevant, I need to know what words were said. If they're irrelevant, then let's limit them, and the jury will never hear them, and we'll move on from there.
I'm looking at the response here. So there was a response as to each particular individual, right? Okay. Mr. Bell?
I think that there is certainly a disagreement as to the law. It's like a theft case. You can prove theft by either endeavoring to obtain or endeavoring to use or use. They want me to say how he's taking something when he may be charged with when he's charged with the use, or to follow up with your homicide, because those are kind of easier when you have a concrete example. If someone drives an individual to the convenience store, gives him the weapon, goes in, he comes back out, gives him some money, and they drive off, they're saying, my guy, the driver didn't shoot him. Show me where he shot him. Or tell me what he said to him. Well, I can show the facts without necessarily the conversation. I think the conversation is also part of it, but that's the proof that I would present at trial. And they are saying, no, under Sarasota, you got to tell us this. And I'm saying, no, I don't. Under Blackford, I got to say this.
You only have to allege in the information or indictment
And
what
that's
they
we've
did,
done.
and there was a conspiracy or whatever. And you don't have to allege every word that they said to each other, et cetera.
Correct.
Is what you're saying.
Respectfully, Judge, every word, okay, not every word, but subject. Your Honor started your conversation with me about, well, do you want to know the subject? Do you want to know specifically what's said? Taking what Mr. Donnelly is saying now, then tell me the subject. Just having a meeting with legal counsel cannot be a violation of the sunshine. But having a meeting with counsel and staff discussing something would be at least alleged by them to be the violation of the sunshine law. So tell me what was discussed.
They have that in the statements that they've got, what was discussed. We turned over the statement. Mr. Wesley gave a statement. They've gone and they've taken affidavits from Mr. Wesley and Mr. Selden. Now they've tailored those affidavits to, did this commissioner tell this person what that commissioner was saying, or did we tell this commissioner what that one was saying? Those are the affidavits that they've submitted right from the witnesses, and that, so I know they have access to the witnesses and what they're telling them.
Judge, they have a burden here. The fact that I can get it somewhere else, the state has a burden in this case, not the civil case. The state has a burden here. I would like them to meet that burden.
Let's see. Here it is. No, that's about prosecutorial misconduct, a motion to dismiss. What I'm looking at is under Mr. Rocky Rodriguez's file. I'm trying to find the response by the state to the motion for statement of particulars. I don't know why I'm not seeing these things.
Judge, I also have one other motion.
Okay, just give me a second. Was there one filed in the Rocky Rodriguez case, do you know?
I think it was an omnibus response, telling us where the meetings were, whether they were telephonically or whether they were at a restaurant. My clients was at a restaurant.
I know Ms. Mackey filed them.
We can make this available to you, Your Honor.
No, that's okay. 1 second. Okay, so what is it, the other motion that you had? So,
The other motion I have is, we learned, Mr. Donnelly shared with Mr. Lyons that there was an expert witness called to the grand jury. It would be our position that when it comes to issues, ultimate issues of fact, whether there's a violation of the Sunshine Law, those are decisions that should be made by the grand jury, and the use of an expert would be contrary to the spirit of the whole fact-finding of the grand jury. As such, we have moved for the state to supply Your Honor, in camera, the testimony of the expert, as well as any jury instructions given to the grand jury. I can't imagine why an expert would be called into a grand jury. They take testimony, they decide what was said, they decide if there were meetings, if that's the state's theory of this, and they decide if there's been a violation, and they indict. An expert to me sticks out like a sore thumb. And if an expert was called to say this behavior is a violation of the Sunshine Law, that would be improper. So I would ask that the disclosure of that testimony be provided to the court for Your Honor to decide whether indeed there has been a abuse of the grand jury.
Okay. I know that an expert, it's my understanding that the one exception as far as an opinion regarding the ultimate issue can be done by an expert, right? In front of a jury.
I don't see how that would happen in a case such as
No, I'm just saying regularly.
Sure, in a marijuana case,
Generally.
marijuana case, the expert comes in and says, this is marijuana. But he doesn't come in and say, having it in the car while you're sitting in the back seat is possession. That is an ultimate question of fact. That is not an expert's domain.
Mr. Donnelly, would
They have to allege something concrete. They can't just come into the court and say, because this person may or may not have testified, I want their testimony. An expert, their testimony, if you just look at the law that they provided to the court as to get Mr. Gorin's testimony to the grand jury or to have the court review it, we think that he testified, we think he might be an expert, we think he may have testified to an ultimate opinion. And yet the law that they even provide to the court says an expert can testify to the ultimate opinion. It just can't be the only testimony, and it can't be in violation of 403 where it's more prejudicial than probative. So I have Mr. Gorin's testimony. If the court wants to take it and review it and see what he testified to, but what I'm saying is it doesn't even rise to that level for the court to even examine it. But if the court wants to, because there's another allegation that I've done something improper, I'll be glad to give it to the court to satisfy the court's any allegation against me.
okay, I'll take that. If you have that, I will take that and read that.
Your Honor,
Yes, sir.
you asked for us to try and agree on a date. Once we agreed on the date, it was a firm date, and it was gonna go, the case, if it got that far, was gonna go to trial. I have that.
We're gonna talk about that in a minute. I just wanted to finish the other issue.
Judge, in summary, if I may,
Yes, sir.
I'm not asking for the state's legal theory. I'm asking for specifically what my client said wrong. Can't be appearing at a meeting. I'd like to know what he said that was wrong. He didn't meet with other commissioners. There's no allegation he met with other commissioners. What did he say to Lynn Barrett? What did he hear from Lynn Barrett? What did he hear from Westerling? Where's the crime is all I ask. Then I can defend it.
Two days. Those are the originals.
Okay. Based on what I've heard and based on my review of the original state's response to the defendant's motion for statement of particulars and the rule in the case law, I'm going to deny the defendant's second motion for statement of particulars. I think that the state has complied with the rule as it stands. I've already will enter an order for the state to provide any Brady material that is in their possession. I will review these documents, okay, and let everybody know regarding those. And Mr. Lyons brought up the issue regarding trial. Let me ask everybody this. I see that all of these allegations are second-degree misdemeanors, am I correct?
Correct.
State, are you looking for incarceration or adjudication on any of these defendants if they are either plead guilty or are found guilty by the fact finder?
We would not be looking for incarceration. We would be looking for adjudication, no.
Okay.
If we go to trial, but
Do any of the
definitely not
defendants
incarceration.
have priors?
No, sir.
No.
Okay. Why would you be seeking an adjudication on all or any of them? If it's their first offense?
I'm sorry.
If it's their first offense, which apparently it is. And the reason I bring this subject up is, it is my understanding under the law, if I certify no jail and no adjudication, then they are not guaranteed a jury trial, and it would be a judge trial. Let me just ask everybody this, because before we get into this, would anybody, well, before that, has there been any discussions regarding resolving these cases among the parties in the state? Through misdemeanor diversion, through pleas, anything like that?
No, Your Honor. I mean, honestly, it's kind of difficult because, as Mr. Laird hit the nail on the head, I don't know how to discuss with my client what she may have done wrong because I don't really understand the accusation.
Okay.
That's a long-winded no.
Okay, all right. Would there be any objection by anybody to a non-jury trial?
No, Your
Sorry
Honor.
to it.
Non-jury trial.
I was gonna bring that up, as a matter of fact, we discussed it today, and, but as far as, Mr. Rodriguez, there's no objection.
No objection from Mr. Robbins.
I'm afraid that that's not a decision that I can make, it's something I have to discuss with Mr. Urick.
Absolutely.
Exactly, on this point, Your Honor, I do have to respond to my client, so I've never looked at this.
I understand 100%. These were just thoughts that I had when I was reviewing all the materials here, and all of us can imagine trying to explain this to a jury. It would be difficult, I think. But anyways, so we won't do anything about that today. We don't have any other dates set, am I correct?
Not to my knowledge, Your Honor.
Your Honor,
Yes, sir.
for the record, Lynn Barrett, I'm also the same position, Your Honor. I hope to confer with my client, but I didn't hear the state respond to the court's inquiry as to what the state's.
You said you had no objection?
No,
I don't think he said
no, I
that.
didn't
Oh,
say
I
that.
thought you.
He did not say that.
At this time, we wouldn't, I couldn't agree to that, Judge. I'd have to consult with the state attorney.
Okay. All right, let me do this. Just let me pull up my calendar. If everybody would put their calendars out.
We had all put our heads together, including the state, and
Came up with a date.
Yes, we did, Your Honor. Either April 8th or April 15th.
Okay, well, that's certainly long enough away. That's not a problem at all. What I was going to do was ask everybody how much time they needed, and maybe we could just all get together and determine whether or not we're gonna go jury or non-jury after everybody spoke with their respective clients, et cetera. Then we can decide, well, we could still set it for those dates, so that all motions can be done and heard, et cetera. You want me to set it as far as a trial date? Of course.
My thoughts are, we know those days, because we, trying to get everybody together on that.
Okay.
We can set it for a status conference to discuss, what you indicated,
What were the dates again?
April 8th or April 15th.
And Judge, I think the idea was just in case it goes longer than 1 week to set it for the 8th, but have those 2 weeks blocked off on all of our calendars, so that we can protect them from other trials, or we cleared kids' spring breaks and all that good stuff.
Let me ask everybody, did we set dates before?
No,
No, we did
you
not.
asked us to get together with regard to that, Judge.
Okay, so,
I think obviously the next step, other than the court reviewing the Gorin testimony, is the preparation and filing of a sworn motion to dismiss, on behalf of defendants and the state's response.
Perhaps the status in December would be a good time to give us all time to discuss those issues with our clients, and maybe there'll be some other discussions with the state and motions may be filed, but.
Okay, so what I'm going to do right now is I'm gonna block off 2 weeks, from April 8th through April 19th. Well, April 19th is courthouse is closed, through April 18th, which is a Thursday. And I will set a status conference in December. What date would be good? We can do it the afternoon of the 14th, the 21st.
I'm out of town starting on the 18th, so the 14th for me
14th would
would be fine.
Judge,
and I know a lot of you are from Miami.
I can be here on the 14th
Okay,
of December.
14th December is a Friday. What I was going to say is, I'm just gonna throw out an idea. If you're from Miami or anywhere, it doesn't matter, and you wanna appear by phone, of course, I can't have you all appear by phone. Or if you just wanna send in a letter stating that we want jury or non-jury or whatever.
Judge, what time on the 14th are you talking about?
What about 1:30?
That'd be good for me.
I'll keep that whole afternoon open.
And Your Honor, I do anticipate that we'll be filing motions
Okay.
right to the indictment.
Not a problem at all. We'll be happy to accommodate you and, my JA is Wendy, and she'll help you set down dates and times.
And I certainly appreciate the length of time you've given us and the courtesy, Your Honor.
Okay, my pleasure. All right, so we'll see you all on the 14th.
Clients are excused, Your Honor?
Yes, sir. And let me just do this. If we could do just a few short orders indicated in motion for, the second motion for statement of particulars is denied on the grounds stated on the record, we can do that, Lisa. And this motion for grading material is granted, the state will provide the council any material under grades.
And the expert witness, is that just gonna happen, no need for an order?
Well, what I'll do is review it, and then I'll send out an order to everybody.
Thank you.
Thank you, Your Honor.
Okay.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Good to see everybody.